Hello everyone, welcome to this session of Understanding Amendment of Pleadings under Order 6, Rule 17 of CPC, that is Civil Procedure Code. What is pleading? Well, Order 6 of CPC covers all the aspects of pleading. Rule 1 of Order 6 provides legal definition of pleading, stating that it is either a plaintiff or a written statement. Plaintiff, plaint are written by plaintiff. It outlines all the claim and accusation of plaintiff against the defendant. Written statements are from the defendant's side, which deals with all the accusation against him by the plaintiff and also provides additional information and other necessary details which may help the defendant in the case. Overall, pleadings are statement in writing that outlines all the argument, contention, facts, and necessary details of the case. It is the foundation stone of any case. The objective behind writing a pleading is to inform the other side of suit against them so that they are not taken by surprises, to allow the court to determine the relevant issue between the parties, to reduce expenses and delay in the process of suit, to eradicate any irrelevance in the suit. The basic rule for writing a pleading is provided under Order 6, Rule 2. It highlights the basic rule, which are pleading should state facts. Facts stated should be material. It should not state evidence. Facts should be stated in a concise form. Amendment of pleading under Civil Procedure Code. Amendment of the pleading is one of the provision. Amendment of the pleading refers to the changes that is brought to the formal written statement that is submitted to the court by the parties. In India, the Civil Procedure Code provides that parties can make amendment to their pleadings during a trial with the court's permission. The purpose of amending the pleading is to make sure that the real issues in the case are addressed and the justice is served. The court imposes a cost to the party that is seeking to amend the pleading in order to discourage malified intentions, provide compensation to the inconvenience caused due to the amendment of pleading to the other parties, and to avoid any arbitrary amendment of pleadings. Amendment of the pleadings can be done in six different ways under different rules. There is a provision for amendment of own pleading or voluntary pleading under Order 6, Rule 17. Now let's understand the provisions of amendment of pleading under Order 6, Rule 17. It states that court may allow either of the parties to amend their pleadings before the commencement of the trial to determine the real questioning controversy between the parties and to ensure that delivery of justice is served to both the parties. Another provision is that court shall not accept any application for amendment of the pleading after the commencement of trial unless the court concluded that the relevant questions or relevant matters are not raised before the commencement of the trial. The commencement of the trial is defined under the case Baldev Singh versus Manohar Singh, which stated that commencement of the trial refers to the final hearing of the suit in limited sense. Court's authority to allow amendment of pleadings. In 1999, the legislature, in order to avoid delay and to ensure that expeditious disposal of suit, deleted the provision under Rule 17, Order 6 of CPC. However, it was reinstated by the Civil Procedure Code Amendment of 2000. The amendment granted the court the authority to approve the amendment of pleading with certain restriction. In the case of Gurdeep Singh versus Rajkumar Aneja, the court emphasized that the individuals of the party seeking to amend their pleading must clarify the altercations, changes, amendment, or modification they wish to make to their original pleadings. The two provisions that are provided for the discretionary power of the court to either allow or disallow the application of the pleading is denoted by the word may. Wherever the word shall is used, the civil court is mandate to permit the application of the pleadings if it is necessary for resolving the actual dispute between the parties. Now, when does the court allows for the amendment of the pleading? First, when the court finds it necessary to determine the real question in controversy, when the amendment of the pleading provides no injustice towards the opposite party, when amending the pleading causes change in nature of the case, when amending the pleading causes a new cause of action to rise, when the amendment of the pleading defeats the law of limitation. Court is more liberal to provide amendment of the pleadings in written statement as compared to a plain. The court will not allow the application of the amendment after the commencement of the trial unless it comes to the conclusion that the party did not raise the relevant facts before the commencement of the trial as stated earlier. Now, when does the court rejects the application for amending the pleadings? When it is not necessary to determine the real question in controversy, when totally different, new and inconsistent facts or matters are introduced in the case that changes the fundamental character of the suit or defense, when the effect of amending the pleading takes away from the other side a legal right occurred in his favor, when the amendment of the pleading is done with a bad intention or when it is not in a bona fide intention. The procedure to apply for the amendment of the pleading. First, a written application should be submitted by the either of the party to the concerned civil court in front of the concerned judge. The applicant should pay a prescribed court fee under Court Fee Act 1870. The applicant needs to communicate the required reason for the amendment in the pleading. Now, the judge, under his discretion, evaluates whether the application of amendment is necessary to determine the real question of controversy between the party or whether considering the application of amendment is necessary to deliver justice to the both parties. After getting an approval order from the court, the applicant needs to file a new pleading within the prescribed time limit of 14 days or before it from the release of the order. The applicant needs to submit a copy of the amended application amendment pleading to the opposite party. The principle the court needs to follow when dealing with the application of amendment of the pleadings are: amendment of the pleading must be liberally constructed to uphold the ends of justice and not to defeat them. The purpose and object behind the rules of pleading is to determine the real questions of real controversy between the parties and not to punish them for their mistake or negligence or shortcomings. The exercise of dictionary power by the court should be governed by the judicial consideration with wider discretion. The rule of amendment is essential and it should be practiced in a larger interest by doing full and complete justice to the parties. The court should not go into the correctness or falsity of the case in amendment while dealing with the application of amendment. Other rules related to the amendment of the pleading. Order 6 Rule 18 states for the failure to amend after order, that is, when the court allows for the amendment of the pleading and the party fails to amend the pleading within the set limit, that is, within 14 days of the date of order, he shall not be permitted to amend the pleading i- unless the court extends the time period. Rule 28 states for the amendment of pleadings are made under Order 1, Rule 10, Order 6, Rule 17, and Order 22 of the court. It shall contain a prayer. The presiding officer shall reject the application if the pleadings amendment of the pleadings is not accordance with the laws or rules. The verbal corrections of the pleading can be made any time with the permission of the court. Rule 29 provides for the legal representatives on the record. It states that when a party dies, then the effect shall be added against the name of the parties, and necessary consequential amendment in the body of the pleading shall also be made as prayed for. When the hires of the deceased party are substituted for him, they shall be entered and numbered consecutively and described as legal representative of the deceased. Law of limitation. Date of application for seeking amendment of the pleading is of utmost importance, even though there is the provisions that says at any stage of proceedings, the court provides for a set time limit of 14 days from the date of application. After, if the party fails to provide the amendment of the pleadings within the 14 days, then the pleading is rejected. In a case of Charan Das versus Amir Khan, court observed that despite an amendment to a pleading was necessary to determine the real question in controversy, the time law of limitation could be a valid defense to refuse it. Now, doctrine of the relation back. Normally, an amendment relates back to the date of pleading, but the doctrine is not absolute, unqualified, or of universal application. In appropriate case, the court may order the amendment would take effect from the date of application was made, or the amendment was allowed and not from the date when the plaint or written statement was made. The criticism of Order 6 Rule 17 are the application of amendment often leads to the delay in administration of justice. The delay causes a backlog of the cases and burden to the court. Order 6 Rule 17 is frequently being misused, acting as a barrier to the swift resolution of legal matters. There is an ongoing debate between the amendment of the proceedings and the limitation that is remained unresolved, with varying interpretations of this rule in different cases. Thank you all for joining this session. Bye.